One advantage of teaching ethics, and I have started the recording here, I may pause it in a little bit, we're sort of doing greeting time as people arrive. But one advantage of teaching ethics is just about any question you ask about the law, paralegal studies, paralegal practice, can be worked into legal ethics. You could ask me about real estate, civil litigation, criminal law, family law. You can ask me any question and I will work it into ethics. And secrecy, confidentiality is the main topic for Module 2 that we're in now. It's one of the major things. There's two major things that sort of divide legal ethics from what I tend to call friendship ethics, or some people call general ethics. And confidentiality in friendship ethics is for a purpose, and it's not absolute. I guess perhaps legal confidentiality is not absolute in all possible circumstances. Okay. Yeah, Nadine has a good comment. And that actually, what would be a good answer to Nadine would actually be a very good question for you guys to ask yourselves, perhaps not ask me, but a comment for, try to come up with a comment for Nadine that would help. Because that's kind of a mind-expanding comment that would help. And she's saying, Nadine, can I quote you? Because people cannot see the chat when they're watching recording. Is that okay? Okay. After the last module, I think after this last module, I will be a paralegal that will be almost invisible. Say, I think you mean let's keep your head down. In other words, say less and keep your head down. Okay, so sort of like the initial, when you're first learning, it can be kind of worrisome to say anything because a person in friendship ethics is used to being able to just express themselves, not having to put things elaborately in writing and get somebody else's signature on it. If somebody calls me up and says, should I cut my yard? I think it's going to rain. I don't have to worry about the person's, assuming I'm not the person's lawyer and I have not been consulted about lawnmower defect lawsuit or something, but I says, well, is your lawnmower in good shape? I might not even ask that. I might just say, yeah, go ahead. I don't have to know anything. I don't have to worry about the fact that it's his problem if his lawnmower is not working right or could be dangerous. You see where I'm coming from? So I'm taking a kind of a roundabout way of dealing with Nadine's problem. Okay. Yeah, and I'm not saying it's a problem. It's not a problem. It's a Nadine is coming up with a concrete plan that she will probably adjust over time and study as she tests out her theories. She'll probably say, well, this was what I came up with. I'm going to turn off. Thanks for using videos, but after a while I turn them off because I'm going to be doing other stuff that soaks up internet power, okay? Oh, very good. Yeah. Yeah, there's one advantage. There is a certain advantage to any law office employee who is more quiet, just kind of quiet and detail oriented. There's an advantage there. My first employee other than, well, my very first employee was my wife, because she said, you can open your own office as long as I can work for you. Because she was a little worried about the riskiness of spending huge amounts of money, opening a law office, having a payroll and all of that. So I said, well, you'll have to accept 100% of the profits as your wages, and and of course initially she would have made a higher wage anywhere else, but yeah, good question, Whitney, but no, you can't. My idea to you is no, you really cannot do that, because they're not coming to you as a friend. They're coming to you as a friend, knowing that you are a paralegal with knowledge. So, or even let's say a paralegal student with knowledge, I would suggest that you just you have to be much more cautious than before you started studying paralegal. Put it that way. Yeah, Nadine has a good strategy here. If you don't know where to draw the line, until you find out where to draw the line, you're going to end up wanting to use Nadine's strategy. That's what I would suggest, because whatever you say, they're going to take it and run with it. That is true even if you become a licensed lawyer in your state. You say something like, oh, go ahead, and they think you just endorsed their whole plan, only part of which they told you about. They didn't tell you the whole story. They told you a single one-sided story without all the information, and you just told them to go ahead and they're going to do it. And that's too bad, because it might not be the best. Hi, this must be call-in user 2. Is call-in user 2, is that Julia Ross?
Yes, sir.
Okay. What are the consequences of breaking the rules? Well, adversely affect your employment with lawyers. It's a possible lawsuit, possible unauthorized practice criminal charge. So I'm not going to tell you that it's uniform and whatever, but the problem is people will not accept that you are giving them a casual guideline or something. They will take it and run with it. The only exception that the instructor came up with the course, the only exception they really came up with was the idea of defining a term. You define the term in order to get the information from them. For instance, if they said, if you were trying to do an intake form for somebody, and they said, you asked me about my corporation name, and it's not a corporation, it's an LLC. Then you could interpret the difference between corporation and LLC enough to be able to get the information in the intake sheet, right? You could use your knowledge of the LLC statute and say, well, I realize it's not exactly a corporation, but I still have to ask you the same questions of who the owners are, who the managers are, and such. Yeah, prima facie. It's interesting because you can certainly define something, but you don't want to affect someone's actions. If you told somebody, for instance, somebody said, well, what's the difference between heirs, H-E-I-R-S, and devisees, in probate, and you said, well, I'll look it up, and you said, here's the definitions, and then the guy said, well, am I an heir? Am I an heir of this person that died? I am a nephew due to being adopted by the person's stepbrother, and you might just say, I don't know for sure. Let's get the lawyer's opinion on that. That would be the best. Take down the information, say, that sounds like a legal question rather than a definition. Okay? So Module 2, the duty of confidentiality, there's very few exceptions. Almost never do the exceptions come up in the actual law office. It's extremely rare. I came very close to it like once. I'm trying to think if I never had to directly use an exception. I was always able to just keep everything confidential. So I cannot remember using an exception. The closest I came, I was about to go in and talk to the judge because I could not, and tell the judge that I was going to have to examine somebody. Oh, this gets kind of complicated, but let's say that a client says to the lawyer, well, I do insist on testifying, but I'm going to try to lie my way out of it if I testify. My response to the client is going to be, then you would have to testify in the form of a narrative, because I will not ask you a question knowing that you are going to lie in response. And the client says, well, if I testify in the narrative and it's not question and answer, you just told me that breaks the normal rules of question and answer. You said I was supposed to only answer the questions that you ask. I wasn't supposed to just volunteer information and just blat it all out. Yes, that's true. I will have to tell the judge that you're going to testify in a narrative. In other words, I'm just going to say, I call my client as a witness, and then I'll have to shut up. And then my client would have said, well, then the judge is going to know that I'm lying. And then my response would be, well, then maybe you better not testify at all. You see where I'm coming from? And you see why it never actually goes to court? Okay. So you will, in your lifetime, you'll probably never see somebody in like a criminal trial or a civil trial testifying in narrative form. Because it gave away to the judge the fact that if the person has a lawyer, the only narrative would be like in people's court where there's no judge, or excuse me, where there's no lawyer. The reason you'll never see it, Hironi, is that it gives away to the judge that the lawyer who's not asking questions is remaining ethical, and that's why he refuses to ask questions, okay? You can't really stop somebody from testifying, but you can tell them the consequences of testifying, and then you have to remain out of it. Well, you're basically indirectly stating that, which is sort of a dead giveaway. Yeah. So in a way, the lawyer would be breaching confidentiality in a kind of a strange, indirect way. Yes, but even there, the lawyer never really has to do it. The lawyer just warns the client of what's going to go wrong, and then the client just has to sit there and not testify, basically. There are issues with technology in confidentiality. One of the simple clues, and this one is not mentioned in any ethical code, but I would state that I want you to consider it. This is sort of where friendship ethics or normal ethics meet legal ethics. But this one I cannot tell you is not going to be on any test in school. But I'm going to just tell you this. This is the rule of thumb. Can you see that on the whiteboard? When you become a paralegal, don't talk about people. One of the things that somebody asked me why I hired and why I kept this really quiet lady on my staff, wondered, what was so great about her? I said, people love to come and see me because they can pour out their heart to her because she never says anything. And if they ask her about somebody else, she just kind of stares at them and she says nothing. So let's say that Bob came to see me, and then later on Paul did. Paul would not only, Paul could not hear anything about Bob because my employee does not talk about people. And that means Paul is also not worried about talking. Does that kind of, you see where I'm coming from? And the fact that this employee also does not talk about Mary, who is not a client, helps. If she does if I had an employee talking about people, how does the new client know that the people that this employee is talking about are or are not clients? They don't. They will assume that it's gossip about people that have been in the office. So so a new client. So, and this is actually true, yes, because this person did not like to talk about people. She didn't even like to, but those that do like to have a little harder row to hoe, so to speak. This is true even if you work as a bookkeeper for the eye clinic. And people say, well, that's not confidential. I mean, well, even that is really confidential. Somebody wears contacts and they don't necessarily want their friends to know that they're wearing contacts. I don't know, and I would say most people are not that fussy about it, but some people are, if you see where I'm coming from. So that would be true even if you were, to me, if it would be even if you worked for the eye clinic. They don't want to know, people don't want to know if somebody was past due on their bill for an eye exam or something, if it's somebody else, even if they would never be past due themselves. But in a law office, it's even more so. It's even a bigger deal. Okay? So in a friendship relationship, if you had two friends, you may decide that sometimes breach of confidentiality is okay if it will help heal the breach between the two friends. But in a law office, you cannot do that. You have to really be quiet about it. Even if you thought you could help, you can't really say anything. So it's actually stricter. Some of the things in a law office that seem like they're not as good as friendship ethics, you have to understand that it fits the adversary system. So there's the When you see something that you don't agree with in legal ethics, it generally is because you aren't ready for the full implications of the adversary system. Adversary system where we are on one side and not trying to help everyone. And that's what often seems wrong, but that is the way that the system is built, and that is what allows people to trust and get advice, okay? So we're going to do a little bit of some game. We're going to do a game show a little bit, okay? Who else has authority to impose discipline? A and B, A and C, A, B, C. To some extent, local judges can sanction somebody for misconduct in their courtrooms. Yep, A and B, correct. C can't. I'm going to say legal discipline. I suppose they could exclude a member. I've never heard of one doing that, but they could, I suppose. But there also would be judges that could do that. The judges can do some forms of discipline in their own courtroom. Okay. Well, it wouldn't be illegal if you signed a contract that said that, Matt. If we formed a bar association, I suppose they could do that, but it would have to be based on contract law. Wouldn't be based on state statutes or anything. Class versus instructor. Answer in 5 seconds to win. Which has authority to regulate licensed attorneys? Nope, you lose. If you said A, you lose. B. Nope. A has no authority, 0. And I want you to memorize that, write it down. ABA is, that's like saying the American Bankers Association can close down a bank. They can't do that. The ABA has 0 authority, and most lawyers have never joined it. I think I belonged for about 1 year, and I was disgusted with their politics and some of their other stupidity, so I quit. But they do some good stuff. ABA does some good stuff because they have scholars. They do pay scholars to come up with some things that are worthwhile. But they have 0 authority. They also, like I say, do some things that I think are quite bad from my point of view. When they recommend judges, they're very partisan rather than being open and fair, and they don't state the grounds correctly. Okay, this one you win. Students win. B is correct. Which is not UPL? Paralegal yells at a client on the phone for failure to attend a court hearing. Paralegal drafts, signs, and mails a letter of advice to a client after speaking on the phone to the attorney about it. Lawyer does a probate proceeding in a state in which the lawyer is not licensed without getting special court permission. Well, this is definitely UPL. So analyze the word not. So C doesn't apply because that is UPL, okay? Yelling at a client might be bad policy, but it's not UPL, okay? Draft, signs, and mails a letter after speaking on the phone to the attorney about it. Doesn't say paralegal signs. That sounds like UPL. Paralegal should not sign a letter of advice, even if they spoke to the attorney about it and read it word for word. That's not a good idea. Get the lawyer to sign it in person or electronically sign it, endorse it, and email it. You could email it to the lawyer. The lawyer could electronically sign it, and then the lawyer could print it out and mail it. Okay, if you're doing remote work. Does that make sense? See where I'm coming from? But even that is a little more iffy. One of the things Mr. E did that I appreciated, very ethical paralegal, he would hover and make sure I read every word. Yes, he was very capable of coming up with that which I said and setting it out clearly in a letter of advice. This is what you told the client. I've drafted it, but I want you to read every word and make sure this is what you wanted in the letter before you sign it. And he was correct. Did you really mean to say that he should not go ahead, Mr. Olson? Yes, I did. Okay. Then I would sign it. Then it could be sent. Okay. So this one, A, is not UPL. The others are. Okay. Which can the lawyer reveal? Price of the house is a matter of public record, but the client said not to tell. Yeah, we don't protect people who are about to kill people. So a lawyer can do this. We don't talk about the price of house if the client said not to tell. Okay. And that annoys the heck out of people. I got calls and I said, I can't talk about it. Well, it's public record. Why don't you just save me the trouble of going to the courthouse or looking it up? I said, nope, can't do that. And that sounds what we used to call Mickey Mouse. But do you see where I'm coming from? If the client doesn't want it told, I'm not going to tell somebody, even a good friend. Even if I'm just giving the good friend the runaround and they're going to find out anyway. Do you see where I'm coming from? That makes sense. It might not make sense to everybody, but it is strict. It's like super strict. It's almost ridiculously strict in certain instances, but why should, if we don't follow, the lawyer is a lawyer is a highly rated person in many ways, but the lawyer is not the boss. Okay, the lawyer is not the boss. The client has to make the final choices. Yeah, Matt is correct. Matt has, as a confidential researcher, Matt has the same problem. Yeah, somebody else can look it up, but unless the people he's working for want him to reveal it freely, he has to keep it confidential, even though somebody else who's willing to do a little bit of work could find out. Like I say, the client is not required to reveal A to the court, but if he intends to lie to the court, that would have to be revealed. Like I say, my method of doing that, though, is my method of trying to save the client and not have the client lie, is just to notify the client. And I did talk to the board about this years and years ago. Notify the client that it's going to be a narrative, that I cannot ask a question. If I can't ask a question, any other lawyers and the judge is going to know what's going on. So we're just not going to, I'm not going to call him as a witness, or he can get another lawyer. You probably have not had a chance to look at this. Microsoft Word encryption, I don't know if anybody has looked this up, but I would say it's somewhat helpful, but it's very breakable. So I would not rely on it all that much. There's a workaround. What this would do would be this would stop casual viewing of something.
Kamar, you drink water? When?
I'm muting everybody because I'm not sure what that was about, but I don't think that was for the course here. Okay. But what MS Word encryption will do, it'll stop casual viewing of the document by someone who gets it by mistake. Okay. So if you send something to an honest person who just is not involved with the case, is not attempting to steal information or something like that, then MS Word encryption, Microsoft Word encryption would certainly help, because they wouldn't be able to read it and they'd realize it wasn't meant for them because they don't have the key to open it, okay? Make sense? Courts and legislatures protect these people with rules against requiring testimony. This is kind of a strange thing. I guess I could look at it that to some extent it's both clients and lawyers, but the basic answer is just clients. But this might be arguable. But clients can waive it. Yeah. So the other thing that is kind of annoying from my point of view is that, and this is something where if somebody who used to be a legal client thinks they're a paralegal and they're not, other clients can tell about my legal advice to their friends and relatives, as if it applies to everybody, and it doesn't. Because they paid for it, they can talk about it if they want. I can't stop them. The fact that this client was given the idea, let's say, some kind of a advice having to do with a business matter or a contract, it may not apply to his brother-in-law, his friend, his neighbor, but he can blab all he wants to about it. I can't stop him. Does that make sense to you? You see where I'm coming from? It's annoying to me, but I'm not protected. I don't have a property right in my advice that I gave years ago. The client paid for it. The client owns it. The client can photocopy it and send it to his brother-in-law or his neighbor. And of course, some part of it maybe is generic. Maybe it would help the neighbor a little bit. But some part of it is based on the client's particular facts. Oh, good question. I'm not accountable for the dumb way that the neighbor interprets it, the neighbor who never saw me. Correct. Does that make sense, Hironi? It does pay when drafting a legal advice letter is to say that this advice is based on particular facts supplied by the client. And that does protect the lawyer. Including yeah, the former client is committing unauthorized practice of law to some extent, but it's so casual that, and the former client, since they're not a paralegal and they're not charging any money for it, they may get by with it. Do you see where I'm coming from? People give each other bad legal advice all the time. And if they have never worked for a lawyer, are not working for a lawyer, maybe it's seen as more casual, so they're not as vulnerable as like a lawyer or a paralegal would be. Okay. If I told one of my Florida students, you know, you don't really need a probate in Florida on that matter, even though it has real estate, because this or that or whatever, that would be probably bad legal advice in a state in which I've not licensed at all. So I shouldn't be doing that. If I help them define a term and advise them to seek a Florida attorney, I've not done UPL. Okay. But if you draft a legal advice letter, you know, and you basically say the advice is based on particular facts supplied by the client, and list those facts, that does help because the lawyer is safer from a lawsuit. But sources to use: introduce yourself. Original purpose of the attorney-client privilege is A, to help guilty people run free. B, because people who can consult a lawyer with confidence will learn to comply with laws, neither or both. What do you think? And this is based on the original, this came out in English law many years ago, it's B. That was the original purpose. And I've got an old book about Old English law from Middle Ages and even before. Just a second here. And to quite an extent, it's worked out that way. It worked out that way in my practice. By gaining confidence with people, they did learn to comply with the laws. They could tell me something, a business person could tell me what they were doing that they thought might not be right, and we could straighten it out before it got worse. If they thought there was no confidentiality, then they would not have told me the facts in the first place. They would have felt, and then I can't get them to comply. The same thing with a criminal offense and all of that. So that was the original purpose. How much is confidential, why, and so on. We will look in Lexis, of course. Breaches of confidentiality, pick a state and go to rules of court. We drill down, why do we drill down? For thoroughness, related laws and rules. It's slow at first, but it will speed your later searches and you learn the structure of the headings. So what do? We go to statutes and legislation. After we clicked on Florida, then we go to local, state, and federal court rules. Then we go to rules regulating. Notice that we click on this. It was a plus sign, and when we clicked on it, it turned into a minus sign. You see where I'm coming from? And I will show it live too, but it's actually easier to see it on the slide. So this is called a drill down. We go to Florida, statutes and legislation, then we go to rules, then we go to these rules. And then you're going to find that when you get to the correct rule, you'll be able to see case decisions, okay? This is the same as the model rule, but wait, there's more, okay? So we went to Florida, state, and then the next category, local, state, and federal court rules, rules regulating the bar, rules of professional conduct, and then client-lawyer relationship. It's a complete drill down, but as you learn the categories, you're learning the law of your state. And you're going to find this is very similar in all states. But if you have trouble in your home state, contact me by text is sometimes the fastest, or by course message, okay? I don't understand the question, Amy. I think this is in Lexis. So we're going to Lexis to find the confidentiality rules for our assignment, okay? Enforceable rules. Yeah, well, it's only Monday, so I don't expect you to know this stuff yet in your home states. When you notice that all of these exceptions are just very rarely used, rarely needed. How many times is a client going to say to a lawyer, at least they didn't ever say it to me that I recall, is I'm going to commit a crime. Don't recall that ever happening. So maybe other people's other sources might have told me something, but not somebody that I represented. If I was warned of a crime, it was not by my own client ever that I can recall, but it could happen that that the lawyer has to prevent a crime by the client. Notice the difference, though, in timing. Don't take it and run with it. If a client says, I have already committed a crime, that's confidential. Yeah, if a client admits guilt but wants to go to court as innocent, yes, you can still represent them, yes. But you can't let them lie in court. Pleading not guilty is not a lie, even if they are guilty of something. Well, you can try to defend somebody based on lack of proof. Yeah, of course, what did they do? Did they have the correct mental intent? Did what they did even violate the law that they're charged with? Okay. Person says, I believe I may have been driving, but by the time I came to in the hospital, I really don't know if I was the driver. You know, so somebody dies in a car accident and somebody who may have been the driver says, I think I did it. I feel so terrible about it. I don't really know that the person did it, even though they say they did. The other time somebody says, you know, I believe that I'm guilty as charged. Sometimes they're not. And many times people say that they're not guilty, and of course, and they are. But it's pretty rare that anybody is going to say that they're guilty if they want to be defended. It's just not often. No, it's not. It's putting the state to its proof. The lawyer's job, the defense lawyer's job, is to force the prosecution to actually prove it. If they fail to do so, defense wins. But my example is not based on murder. My example is based on driving after revocation in my home state, okay? In my home state, if a person is accused of driving after revocation, that is a misdemeanor, which is considered a crime. If the prosecution, let's say the prosecution does not have any paralegals on staff, which is pretty foolish, and so nobody is really going through those files in enough detail, they show up without something called a certified copy, I would win the case. If they cannot prove that they had notified somebody officially that their license had been revoked, if they forgot their proof, they lose. You see where I'm coming from? You snooze, you lose. One of your jobs as a paralegal is not to snooze. If you're working for the prosecution, don't snooze. Go through every single doggone file and make sure that the proof is in the file. If it's not there, be assertive and say, hey, the proof's not there. Hey, boss, do you want me to write a letter asking for a delay or a motion, or what do you want? Because we don't have the proof. The state didn't send us the proof. And be assertive, don't be a marshmallow. Oh, if the lawyer's dumb enough to go to court without the proof, don't be a marshmallow. Say, same thing, mischarged. If something's mischarged, the person's guilty of something, but they're mischarged, don't be a marshmallow, okay? And on the other side, if you're helping a defense attorney and somebody's mischarged, don't blab to the paralegal for the other side. That's not your job. If they screwed up, if they snooze, they lose. Okay? It's kind of, sometimes the adversary system is a nasty, tough thing in a way because total justice is not done. But that is part of the push-pull. Adversary system works great when both sides do their jobs with intensity. The adversary system fails when one side is either overzealous or snoozes. Overzealous is almost as bad. I think it's even worse, maybe. I had to defend cases against an overzealous prosecutor, and he kept annoying the heck out of judges. And I thought it was I actually went to his boss and I said, I don't have a case against him right now, so I can tell you something, but it's too easy to win. This guy's over the top. If a prosecutor goes over the top and is pushing cases that should have been dropped, then that prosecutor loses credibility just when he needs like a search warrant, or he needs to have a case continued that should not be just dismissed. Do you see where I'm coming from? So you don't want your boss to lose credibility. You don't want to lose credibility yourself. I mean, it gets ridiculous in some cases. Two play friends, get in a dispute, and they're not even really teenagers, or if they are, they're very juvenile type teenagers, and they get in some kind of a dispute. It ends up in juvenile court with a kind of a juvenile offense, which is based on a criminal offense. Well, the prosecutor needs to use common sense as well as the law and say, well, the mom settled this. The person wanted to stay for lunch and wouldn't leave. And yes, we did get the cops there. I'm embarrassed, but we settled this. The prosecutor needs to just say, I'm going to let this one go. I'm not going to embarrass the police officer. I'm not going to embarrass the court, the judge, whatever. Anyway, once you get to the correct rule, then you have case decisions. So if you click on the case decision, you can see how the a rule is interpreted. Okay. So that's why we're doing this. So we're going to scroll down in Lexis and pick a state. And I'm going to look up confidentiality in some states. Let's see if we can do this live and it will work. Is that okay? Since I did Florida, can I do Florida first, or do you have other states? I know I have at least one Florida student, at least a couple. What other states do you want? Man, Illinois, okay. Florida, Minnesota, Illinois, okay. California, okay. Okay, we're going to try this. Okay, can you see the Lexis? So we have the Lexis Advance up here, which we can always get back to. Guys see? Okay. Now, I don't do a search up here unless I know the citation. What I do is I scroll down and I go to one state at a time. For one thing, I get to know that state laws well enough to where I'm not lost anymore. So I go to Florida. I get some idea of the structure of the law of that state. It's different in each state somewhat, although you're going to find a lot of common things. So I don't want cases to begin with, and you said, no, you did want cases. Well, I eventually want cases, but I want to see the structure of the rules first. So I'm going to go to statutes and legislation, and I realize that in most states, state and federal court rules are not part of statutes and legislation, but they are in Lexis. Okay, so I'm going to click on Florida local, state, and federal court rules. Okay. And then I'm going to scroll down a ways. I'm going to go, I think, rules regulating the Florida bar, I think is the one that we used, isn't it? That I have on my PowerPoint. And then I'm going to use Chapter 4, Rules of Professional Conduct. What I did was I clicked on a plus sign, and that opened it up. And then I'm going to click on the plus sign to the left of Chapter 4, Rules of Professional Conduct. And then, as I recall, 4.1 client-lawyer relationship is where they have the confidentiality duty, so I'm going to click on that plus sign. And of course, there's all kinds of things. The one you should skim these so you know what's there, and then drill down to the one we need this week, which is confidentiality. And I realize we've already looked at this in the slide, but I still wanted to do it live. This is not the same numbering as the ABA uses. Some states are closer to what the ABA uses, which is fine. But it's there. This is almost the same as the ABA, but this is enforceable and the ABA is not. Okay. Then you want to know how the Florida court system interprets this, and you just scroll down. And then you can see what happens in the court system. Privilege is where the attorney does not have to testify, though. So that's slightly different than just regular confidentiality, but it's really super related to that. If something was not confidential, it wouldn't be privileged from the lawyer testifying. And again, if the client wants the lawyer to testify, unfortunately for the lawyer does have to testify. Kind of awkward. Lawyers would just as soon it be double confidentiality, I'm sure. That would be nice. So now I'm going to go to another state. So I'm going to try Minnesota. If I can't find Minnesota, I'm in difficulty. But Minnesota. Clicked on Minnesota. Again, I went to statutes and legislation, state and federal court rules. And Minnesota, for a medium-sized state for population, we have a lot of rules. And we have Minnesota Rules of Professional Conduct, which is quite a ways down here. I couldn't even see it until I scrolled down. So I'm going to open that up by clicking a plus sign. And then again, aha, this looks the same as Florida, but the numbering will be a little different, I believe. And Rule 1.6, confidentiality of information, okay? And somewhat, not exactly structured exactly the same as Florida, but it's basically got the same content. And again, well, you've got a commentary, but then if you scroll down far enough, you get to case decisions again. I'm going over time, but if you can hang on, I will get to your state, okay? Because this will help you meaningfully learn things that are skills. And if you can scroll down here into your state, your home state, you have a skill that you can use at work. You can say, well, boss, the latest court decision on our rule is different than the one we relied on last year. And he says, well, how did you know that? Well, I looked it up. I went to the courthouse, or you had a Lexis subscription. It would be the same basically in Westlaw or Lexis too. Fast Case would have this, but typically does not have the court decisions. You can learn to look up court decisions with Fast Case though, directly. Okay, Supreme Court rules, I believe, is where these are here. And rules of professional conduct, which be Article 8. Now, how did I know that it was under Supreme Court rules? I just knew it from having looked before, okay? If I didn't use table of contents, though, I would be lost. But I've been using tables of I shouldn't say I'd be lost. I would be spending a lot of time with it, okay? Now, Rule 1.6, again, this is the same as Minnesota, and I believe the same as ABA. So very similar. But I had to look it up under Supreme Court rules in Illinois. And again, very similar language. Scroll down past the commentary, past the case notes, and into the actual case. And if you click on one of these cases, you get to the case that interprets it. You get to the full portion of the case. California, I have not memorized where theirs is. I will have to by guess and by golly, okay? Statutes and legislation again. Local, state, and federal court rules. And I will try this at the top. California Rules of Court. I'm guessing this. Rules on Law Practice, Attorneys and Judges, Title IX, I'm guessing. Not sure. Oh, okay. That was not the main rules. Here's what I want. I think rules of the State Bar of California. So I'm going to close up all of that. And I'm going to go down to rules of the State Bar of California. Okay. And I'm guessing title, and let's see. Oh, I'm guessing below Title VII, rules of professional conduct. That's what I'm guessing. Okay. So even somebody like me, I had to do a little bit by guess and by golly. But if I had been totally stuck, what would I have been able to do? I would have been able to call up or use help within Lexis. and I will give you the phone number to use for Lexis too. And I think those were all the states you wanted. Had I been totally stuck, I would have used the Lexis Help Advanced line. Okay, I didn't do Virginia. Okay. Okay. And I better put it up on the big board here too. And there is the Lexis Advanced Helpline. So if you know you want confidentiality rule of professional conduct, they can get you there fast, but you should ask them how they got there so that you can go back there yourself next time. No, because there's a quiz, but it's a regular quiz. There's no attendance quiz this week. Okay. I'll type that up here. This would be the regular quiz. Okay. Well, Desmond, one of the problems with the calendar, that reminds me, you have to click on the calendar entries because you can't read them until you click on them. You used to be able to hover, but okay. So not everybody has, if people are not used to online ed, they don't click on everything, okay? So one of the things to do within calendar is to, and I will demonstrate that even though not everybody needs this, but hang in there if you're not sure what I'm talking about. Of course, you're going to see my calendar. Let's see, is there a way I can show you student view of calendar so you don't see too much stuff. You don't see everybody else's calendar. There we go. Okay, that helps. Share content. Okay, so it says start assigns. To be able to see it, you have to click on it. Okay? If anybody has trouble with the mechanics of courses, okay, I did student view on mine so that I wouldn't show all my sections, just show one section. But mechanics of courses, problems you have that will affect your ability to do all your courses, you can call support. Call Rasmussen support, okay? and I put that on the okay, and I put that up there for people watching the recording. And now I'm going to stop recording.